Okay. Thank you, everybody, for coming. So this is meant to be a public informational session to which we have invited the public to ask questions about the marijuana law in Massachusetts. And the Select Board is really looking for public input as it contemplates warrant articles for a special town meeting scheduled for Wednesday, October 10th. And we apologize about the time confusion of this. We had always scheduled it for 5 o'clock, and I understand that it was incorrectly printed in the paper as 6 o'clock. His fault. But thank you all for managing to figure out that it was at 5. And anyway, what we'd like to do is give you a brief overview. Town Council here, Katie Loftman from Copeland and Page, KP Law, is going to give us everybody a brief overview. And some of you may have heard this overview before. Katie's been to Select Board meetings a couple of times to give it. But our intent with this particular forum is to really welcome questions. If anybody has questions, now's the time to get at it. We have another forum scheduled for June 4th, Monday, June 4th, that is sponsored by the Chamber of Commerce and WACK Radio. And that is more of a public forum that they have offered to host for people to express their opinions about what they think the board might want to consider for warrant articles. So the board has been talking about this quite a bit. There are different ways to address this zoning-wise and general bylaw-wise and license limitation-wise and or not. So we asked the school committee, the Board of Health, and some other groups to come to board meetings in the coming couple of weeks, to 3-4 weeks, to express their positions. And we have yet to hear from any of those groups because they're still kind of formulating those positions, but we expect that in June we may be hearing from them. So I'm going to turn it over to Katie, and again, any questions at all is now's the time. It's not the only time, but it is a good time.
But I am here now.
If there is questions, should people just kind of raise their hand and ask you as you go, or do you want to wait till you go through your presentation?
I'm happy to take questions. I'm the only one here for the speaker list, so I'm happy to take questions as we go if there's something that comes up on a particular point. So as Libby mentioned, my name is Katie Lockman. I'm with KP Law. And I'm going to talk tonight a little bit about commercial marijuana and how that is going to look as an industry and how that is going to be regulated both at the state level and at the local level, just to give everybody an overview of how this industry is going to play out. So the first thing I want to sort of lay the groundwork for is the types of commercial uses that we're going to be looking at. And this is on the recreational or adult use side of the spectrum. This is what was legalized by the ballot question number 4 back in November of 2016, and what the state regulations that were just recently issued by the Cannabis Control Commission govern. So the umbrella term for these commercial uses is marijuana establishment, and when we refer to marijuana establishment, it includes a whole subset of commercial uses. And each one of these is subject to a separate license from the state. So you can have a license to cultivate marijuana. You could have a separate license to be a retail marijuana retailer. You can have a license to be a product manufacturer. That is going to be the people who make, for example, like the edible products or the tinctures and creams or oils or things that are sold that infuse the marijuana into them. There's also a separate license category for independent testing laboratories, and then there was a general catch-all for other licensed marijuana businesses. The one thing that is not included in this definition is a medical marijuana treatment center, and we're going to talk about those in a little bit more detail later. But a medical marijuana treatment center is a separate type of use that's regulated separately by the Department of Public Health, and it's not part of this umbrella of marijuana establishments. When the Cannabis Control Commission came out with their state regulations, they created 4 other categories of licenses for the time being. They created a craft marijuana cultivator cooperative, a micro business, a third-party transporter, and an existing licensee transporter. So those are all of the commercial uses we're talking about, and the reason that it's important to sort of understand each of these separate license categories is because it gives you a good sense of what is going to be appearing at the local level and what's going to need to be regulated as a separate type of use at the local level. So I'm just going to briefly summarize what each of these uses entail. So a cultivator is they're able to cultivate. They're also able to process and package, and they can transfer the marijuana that they grow to other marijuana establishments. So for example, they could send it to a product manufacturer, they could send it to a retailer, but they cannot sell direct to consumers. A marijuana cultivator can have up to 3 cultivation locations on a single license. And the way that this is going to be regulated on the state level is by canopy. So a canopy is considered a certain square footage of grow space of mature plants. And the maximum amount of canopy that you can cultivate under a single license is 100,000 square feet. But you can distribute that, across various locations, depending on how many licenses you have. A marijuana product manufacturer, these are the individuals that they're going to obtain the product, manufacture, process, package, and they can also, sell wholesale to retailers, but they cannot sell direct to consumers. Now, the craft marijuana cultivator cooperative, this is really just a type of business organization. And it's supposed to give some preference to local business, to smaller growers, and it allows Massachusetts residents that are organized as this limited liability, limited partnership, or cooperative to cultivate, manufacture, process, package, and brand marijuana. And again, it's something that can only be sold to other establishments, but not directly to consumers. They can have up to 100,000 square feet of canopy, but it could be spread across as many locations as they want for a single cooperative license. A micro business, again, this is like a business that is meant to favor the small scale applicant. So it's a tier 1 marijuana cultivator, which is a 5,000 square foot canopy limit, and a marijuana product manufacturer co-located. And there's a limit on how much they can actually have in terms of their product manufacturing. They're limited to 2,000 pounds in an annual year, annually. They cannot have any kind of ownership stake in any other business, and they have to be residents of the Commonwealth for at least 12 months before an application. So these 2 license categories, really subsets of product manufacturing and craft cultivating, but designed for specific applicant classes. So the marijuana retailer, this is what most people think of when you think about commercial marijuana. It's the place that you go to buy it. So a marijuana retailer, they can purchase and deliver marijuana products to and from other marijuana establishments, deliver, sell, transfer to consumers and other establishments, and they can co-locate with a medical marijuana treatment center or dispensary. I have a few pictures of what some of these look like. These are actual medical marijuana dispensaries that are currently open within the Commonwealth. The one on the left, I believe, is in Northampton. The one on the right in Brookline. And I think this one might be in Lowell, but I may have to verify on that one. So again, a lot of these are coming in as fairly upscale, really sort of well-maintained establishments. They're not necessarily like the corner neon light shops that you might associate with what has been permitted in other states. So this other type of marijuana use that has been licensed by the Cannabis Control Commission is a marijuana transporter. Now, this is not to be confused with delivery. As of right now, there is no license authorized in Massachusetts for home delivery of recreational marijuana. The Cannabis Control Commission considered doing that. They didn't put it in their initial final regulations. They're going to perhaps do some more study on that and maybe open that market to that use later. But for right now, you cannot have a delivery operation, but you can have what is known as a marijuana transporter. And the whole idea behind a marijuana transporter is that you may have an establishment that is cultivating their product, and it may be, for example, a craft cultivator, or a micro business, which is a small scale operation. But in order to get that product to retail market, they have to be able to transport it. And there are very strict regulations in place with respect to how marijuana is going to be transported. It has to be in very secure vehicles, has to have a minimum of 2 individuals in the vehicle. It has to have cameras and special equipment and tracking devices. So you may not want to invest in the type of infrastructure that you would need to transport your own marijuana. So what the Cannabis Control Commission did was they created a separate license category for transportation, which allows people who want to get into the business of transporting marijuana, who don't actually own their own establishments, to get a license to do that. Marijuana research facilities, these are academic institutions, not-for-profit corporations or domestic corporations that will be able to acquire marijuana for the purposes of research and testing. They cannot sell marijuana cultivated under their research license. Independent testing laboratories. Now, this is a really interesting one for Nantucket, and that's because the way that the commission has set up its regulations, anybody who's cultivating and processing marijuana is going to be involved in what's known as a seed to sale tracking program, where from the moment you plant that seed to the point that it's sold to the public, it's in a database, and you know which plant, which strain, which entity, who bought it, who grew it, who sold it, so that you can have a really tight control over the product and the number of plants and where they are at any point in time. They're all going to be on these little scan devices. Part of this process is going to involve these plants being tested at an independent testing laboratory and the products that they're being produced as a result of the cultivation. And the state is putting in place a number of testing protocols, and everybody's going to have to send their product samples to the testing laboratory to be tested, and it's going to have to meet this strict criteria in order to go to market. The problem that we have in Nantucket is that it's going to be very difficult for people who are growing, cultivating, and processing here to get their product to an independent testing laboratory, and that is because you cannot use federally regulated water or airspace to transport marijuana. So the only way that that this product could be tested is if there was an independent testing laboratory here on the island. And realizing that that might not be an economically feasible venture, what the Cannabis Control Commission did was put in place special regulations for Nantucket and Martha's Vineyard, which basically exempted anybody growing and cultivating here from the requirement that it be tested by an independent testing laboratory until such time as a laboratory might locate here on the island. And if there is no such island, no such entity on the island, they still are required to test products. They have to meet a certain sort of limited testing protocol, but they're also going to have to be sold with a warning label that says they haven't met the same testing standards as other marijuana product within the Commonwealth. So that's a special regulation that was put in place to help the industry to be able to take root here and on the vineyard, but still basically comply with federal regulations. So the last type of use I want to talk about, again, this one is not under the CCC umbrella just yet, but it's the existing medical marijuana treatment center. And I know this is really confusing, but because medical marijuana was not part of ballot question 4, it came into being in 2012 under a different citizen petitioned ballot initiative process. That got assigned to the Department of Public Health for its regulatory controls, and they chose to put in place regulations that control medical marijuana as what is known as a vertically integrated license scheme, meaning because marijuana was not legal in the Commonwealth at that time, the only way to really track what was going on was to have anybody who wanted to engage in this business both cultivate, process, manufacture, and sell their own product. And so what they did is they put in a single license for those uses that allowed anybody who came in to get a single license and do all of those uses under that one license category. So that still exists right now. So on the adult use recreational side, we're looking at everything as a separate use category, a separate license category. But on the medical side, we're looking at it as a sort of a total package operation. The transfer of oversight for medical marijuana treatment centers is going to be going to the Cannabis Control Commission at the end of this year. They are charged with new regulations. I've been pushing them to say, hey, what are you guys thinking about in terms of, are you going to make these two licensing schemes, match up a little bit more closely? They don't know yet. They've been so busy with trying to just put in place the regulations for this that they haven't, and get people licensed, that they haven't really turned their attention to it yet. So that's kind of a stay tuned, we'll wait and see. But I think over time, you're going to see these two industries come together and be licensed and regulated on the state level in a more uniform way. But for now, medical, separate, different licensing scheme. So the one thing that is not covered in all of these uses that we just covered is this on-site social consumption, and that's been a concern in a lot of communities as to whether or not this is a use that's going to be allowed, a use that can, come in under a separate license. As of right now, the Cannabis Control Commission has put the hold on social consumption. They have not created any license category for it. Nobody can become licensed as a social consumption retail establishment. That is going to be something that they take up within the next year. They say next February they're going to start doing some further research and study on this as a potential use. But for right now, nobody can get a license for this, and you can't actually even include it as a use under your zoning unless it's petitioned by citizen petition ballot vote, which requires 10% of the number of voters in the city or town voting at the previous state election. And it can only be on a biennial state ballot. So that means that social consumption as a use is at least 2 years out, because they would, even if somebody put it on the biennial, the November ballot, the CCC hasn't licensed it yet. So it's probably going to be at least 2 years before we see any kind of movement on citizen petition ballots for social consumption, at which point in time the CCC may have a license category for that use. All right, so that was really just a quick overview of the types of uses that are going to be part of the marijuana industry. Here's the timeline for how this is all playing out on the state level. So on April 1st, the CCC began a process of certifying priority applicants, which included anybody who had an existing marijuana treatment center license, and then this category of economic empowerment licensees, which were people who are minority, people of color, and people who live in communities that were disproportionately impacted by marijuana arrests, and that is not Nantucket, so you're not going to have any economic empowerment on that side, but you may still have minority priority applicants. So they have begun accepting license applications for the priority applicants, and they opened on May 1st for cultivation, microbusiness, craft cooperative, independent testing laboratories, and laboratory agents. So that licensing process is currently ongoing at the state level. And on June 1st, that's when they're going to open their license application process for the retail, product manufacturers, and transportation, with the thought being that they have to get the cultivation licensed before anybody can have anything to sell. So they've kind of done a tiered or delayed rollout. So if you want to become a owner or licensee of a marijuana establishment, you're going to have to get a state license. And the state licensing process includes basically 3 parts. They're referring to them as packets. So an applicant has to file a completed application in each of these categories. They have to be able to file an application of intent, which shows their incorporation, their capital, their bond, their property interest, and a bunch of municipal information. And then they have to be able to show a positive impact on disproportionately impacted communities. Then they have to complete a background check process, and that's going to require disclosure of all of their executives, their managers, the people they're doing business with, their fingerprinting, their criminal background checks to make sure that everybody who's involved is, qualified and able to conduct the affairs of the business. And then the third packet they have to do is this management and operations profile. And that includes a lot of the details of their business, including like their business plan, their operating policies and procedures, their training plans. Now, applicants can file these in any order. It's not a stated order. You don't have to file your application of intent before you do your management and operations. You can do them in any order. But an application will not be deemed complete at the state level until you have all of the information in each 3 of those packets. Once you have a completed application at the state level, they have 90 days in which to act on that application. So what I really want to focus on tonight is what is the municipal role in the application process, and then how are municipalities regulating these types of uses on the local level. So as part of this application process, a municipality is going to be required to do 3 separate things. There's going to be a community outreach hearing or meeting that the applicant is in charge of conducting. They're going to have to enter into a host community agreement with the applicant, and they're also going to have to provide certification that the applicant is in compliance with local zoning, including any buffer requirements. So this community impact meeting is actually, from a municipal law perspective, I think a really good idea and a really good creation of the regulations, because what it requires is that an applicant come to the community up front before they start any of this licensing or permitting, and they have to hold a meeting, and they have to say, here's what I'm planning on doing, here's where I'm planning on doing it, and here's the impact I think it's going to have in the community, and give me all of your, give me all of your feedback before I get too far into this process, and let's have an open dialogue. So I think it's a really effective tool if applicants use it as that. This has to be held within 6 months prior to their submission of their state license, and they have to advertise the meeting at least 7 days prior to the meeting taking place. They have to provide notice with the town clerk, planning board, contracting authority, or local licensing authority if there is one, and they also have to notify abutters. At that community impact meeting, they need to discuss the types of marijuana establishments they're proposing to locate. They have to provide their security information, the steps that they're going to take to prevent diversion to minors, their plan for making a positive impact in the community, and then any information that they have that will demonstrate that their location will not become a nuisance. And they are required to have a question and answer session from community members to answer any questions that people have. The host community agreement, that's the second part of their application requirement on the state level. If you are a marijuana establishment or a medical marijuana treatment center, you're going to have to enter into a host community agreement with the community that allows for a community impact fee. The community impact fee is capped at 3% of the gross sales, and it's limited to a 5-year term. But there's nothing that precludes a municipality from renegotiating every 5 years their community impact fee. Applicant has to certify to the Cannabis Control Commission that they've entered this agreement in order for their state license to go forward for even consideration. So if they don't have this agreement, if they can't reach terms with the municipality, they can't move forward on the state level. The nice thing about host community agreements, and this again is something that I think really stands to benefit communities, is that there's really broad contracting authority for municipalities to consider the impacts of these establishments and try and put in place contract terms that mitigate or offset those community impacts. So it's not really just about imposing a fee. It's about thinking about where is this entity locating, what are going to be the impacts, and how can we address those, and how can we get to an agreement by contract that allows the municipality to most effectively benefit from this establishment locating within the community. So then the third part of the application on the state level that municipalities play a role in is this certification of compliance with zoning. This is something that happens once an application is complete, so those 3 packets are all together filed with the state. Then the state says, all right, we deem this complete. We're going to outreach to the municipality and say, is this applicant in compliance with local zoning? And by in compliance with local zoning, they're not asking whether or not they have secured all of their permits. They're really just saying, is it feasible for this entity to locate in the place where they're proposing to locate? Does your zoning allow, be it by special permit, be it by right, are they allowed to locate there? The special permitting can come down the road. It doesn't have to come up front, but the municipality has to certify that it's feasible for them to locate where they proposed. So now we're going to just sort of transition into what it is that a municipality can do to regulate these types of establishments on the local level. So the Act allows for municipalities to impose time, place, and manner restrictions, that's generally your zoning bylaw, which governs how establishments are going to operate and the terms under which they are going to operate. So this can include special permit or site plan review, can designate particular districts in which the uses can locate. There's also a provision that allows for municipalities to implement, in addition to zoning controls, local licensing controls. So you can have, on the one hand, the applicant has to go to the planning board and get a special permit and go through site plan review. On the other hand, they can also be required to go to the Board of Selectmen and get an annual license to basically monitor what's going on from a licensing standpoint. Yes.
And the community impact, excuse my voice, the pollen's got me. The community impact meeting for recreational has to be done 6 months before. But for medical, that isn't necessarily the case, is that correct?
That's right.
Because I know that it was kind of the opposite, medical done out here.
Yeah, so medical does not, at this current point in time, have a requirement for a community impact meeting. They do have a requirement for a host community agreement, and they do have a requirement that there be a letter of support or non-opposition from the Board of Selectmen, which sort of functions a little bit like this certification of compliance with zoning, although it's a little bit broader in its scope and a little bit more discretion given to the board with respect as to whether or not they issue that kind of a letter on the medical side. So buffer zones, there is a statutory buffer zone that is imposed on adult use recreational establishments, which essentially provides they cannot be within 500 feet of existing public or private schools. You can reduce that distance. You can't necessarily increase it. I'm going to talk in a minute about what's currently in Nantucket's local zoning, but there's been an open question as to whether or not the types of uses to which you apply a buffer could be increased from just schools to other types of uses. And that's based on the fact that when medical was put in place, they did have a sort of a default buffer that was imposed that included uses such as daycares or places where children commonly congregate. Medical was medical. Recreational is this less restrictive, but municipalities do have the authority to increase that buffer to other types of uses if they choose to do so through zoning. And that's sort of been an open question, but a number of communities have done that, and it appears that the Attorney General is recognizing that authority. Zoning moratorium, this is something that, again, I'm going to discuss with respect to what's currently in place here, but many communities have done this, basically put a temporary freeze on adult use marijuana establishments, in order to have a period of time in which communities plan for these types of uses, decide what kind of local controls they want to put in place, go through the process of adopting those local controls, and then once they've done that, the moratorium goes away and you have your zoning in place. And it makes a clearer picture for everyone as to what's allowed when. And so Nantucket has imposed a zoning moratorium, which is going to be in effect until the end of December of this year. So this is just a summary now that you sort of know what we can do with respect to regulations. I'm just going to summarize what Nantucket has done with respect to those time, place, and manner restrictions at the current point in time. So in November 2017, the town adopted a temporary moratorium that applies just to the adult use recreational uses. Medical is still open. There was no moratorium on those right now. And as I said, I sort of summarized that process already. The town also adopted local zoning with respect to adult use recreational marijuana. And what it basically did was created a definition of a marijuana establishment on the recreational side. And the language of that definition really tracks the language that I quoted at the beginning with respect to all those different types of uses that fall under that use umbrella of establishment. So it's cultivator, testing laboratory, product manufacturer, retailer, or any other type of marijuana licensed business. They're subject to the following standards. They have to be in standalone facilities. They can be co-located with a licensed marijuana treatment center. There has to be a minimum of 500 feet separation. This is your buffer between the school uses. And they have to secure a host community agreement before a building permit issues. So that's the sort of the full scope of the local zoning. But again, the moratorium is in place, so this is really not fully come into effect and will not come into effect until January 1st of 2019. So these recreational marijuana establishment uses are subject to special permit currently under the zoning bylaw, and they are allowed in 2 zoning districts, the CI and the CN. And I know hopefully this map is clear enough that you can sort of see where those districts are in the town. So those are the places where adult use recreational marijuana establishments of any of the types I described can locate. This is also the area in which medical marijuana treatment centers can locate. Those 2 uses are treated the same in terms of where they can locate right now.
Question for you, Katie.
Yeah.
Just an example, Key Post Corner is, a large building with 3 or 4 different businesses in it. Could a recreational use be in there, even though it's connected in the building with a computer store?
So just to go back to the language that was put in place with the zoning, right now there is a requirement that they be in a standalone facility and not allowed within a building or structure containing other retail, commercial, residential, industrial.
No retail, no residential, no anything.
If there are 2 retail establishments on one property, but both in standalone buildings, would that be feasible?
If it's the same lot, I think that would probably pass the definition here. Yeah. So there are a couple of other things that the Act allows municipalities to do in terms of regulation, which have not yet been considered or passed in terms of zoning in Nantucket, but which have been the subject of some discussion. And so I just want to highlight what those options are. Under 94G Section 3, there is the option for our municipalities to prohibit or limit recreational marijuana establishments. Now, marijuana is confusing in a lot of different ways in terms of the way this all got put into place. Not the least of which is that it is a use category that's being treated differently than all other types of land use in Massachusetts. And the way that land use generally works in Massachusetts is that you have to specifically define a use category in order for it to be allowed within your community. So the example I like to give, because I had an enormous litigation involving this in one town, was an asphalt manufacturing plant. And the question was, like, if the town hasn't called out asphalt manufacturing as a specific use allowed, can you come in and manufacture asphalt in that community? Marijuana is a use that is being deemed allowed even if a municipality doesn't put in place specific regulations to address it. You cannot interpret your zoning bylaw as prohibiting this use just because you stay silent on it, which is why we took action last November to call out these uses specifically. Because that is the way marijuana is being treated as a land use category, if you want to prohibit it, you have to take a specific action to do so. And that is set out, the procedure for doing that is set out in the Act. Also, if you want to limit the number of retail establishments that you have operate in your community and that limitation falls below a particular threshold, there's additional procedures you have to follow in that case as well. Same if you want to impose a limitation that causes the number of establishments that you have in your community to fall below the number of medical marijuana treatment centers registered to engage in the same type of activity. So these are the 3 types of prohibitions or limitations that the Act contemplated. And I'm just going to quickly summarize what you have to do if you want to have any of those limitations. The procedures you follow depend on whether or not you voted yes or no as a community on ballot question number 4. Nantucket was strongly in favor of ballot question 4, and so there's a 2-step process that has to be followed. If you want to prohibit any type of establishment, or if you want to limit below that threshold, which is linked to your package store liquor licenses, you're going to have a ballot vote, and you're going to have to implement that vote through the adoption of a bylaw. Now, a lot of municipalities that are looking to allow these uses, but not, uncap. They want to pose a cap, but not like a really strict cap. They're looking at that ballot requirement and they're saying, well, what happens if we go above that threshold? Well, if you go above that threshold, you don't have to have the ballot vote. You can just implement a bylaw imposing a limitation. So, for example, if you want to have the number of retail marijuana establishments in your community linked to 20% of the number of alcoholic beverages licenses that you have, basically your package store licenses, by capping it at 20% as opposed to below 20%, you eliminate the need for that ballot vote, and you can just have a bylaw that implements that type of limitation. So one question I always get when municipalities are considering whether or not or how they're going to regulate marijuana is, well, what's in it for us? And this is something that Nantucket has already done. They were sort of they were leader on this issue, adopting this right when it came out. But this Chapter 64N of the general laws allows municipalities to impose a local sales tax of up to 3% of the gross sales on retail transactions. And Nantucket voted to accept that full 3% at its last special town meeting in November of 2017. So to the extent any retail operations open in this community, they're already going to be subject to that, and Nantucket will collect that revenue based on that vote.
So Katie, the community impact fee and the sales tax are different.
Yeah, so that was just,
Come on, I was going to ask that question.
sorry.
What's wrong with
Sorry, I
you?
didn't see your hand up.
We just must be thinking the same.
well, I was actually going to just cover that point. So we're all on the same wavelength.
Right, we're there. Okay,
So,
good.
the other way that communities stand to benefit is through the host community agreement, which has that community impact fee, which is also, confusingly enough, 3% of gross sales. That community impact fee is supposed to be linked to the actual impacts in your community of that use, and you're supposed to spend it on police and fire and public safety and health and addiction recovery, whatever you feel those impacts are. That's where that 3% goes.
And I believe we voted that in this last annual town meeting, or the one before,
It's special.
the special we did. Right.
No, that's specific to the host community agreements. On the community impact fee,
Oh, for each
The-
CHA.
for each entity that enters into, you can negotiate up to that 3% for your community impacts. Those are the ones that have a 5-year life. On the other hand, the 3% sales tax that you collect, it's specific to retail establishments. So you're not going to be collecting 3% on your cultivators or your product manufacturers. But it is not earmarked for any specific purpose. It goes into the general fund. It can be expended for any type of municipal expenditures that you would expend those types of fund for. 3% sales tax, retail only, 3% host community agreement, specific to actual impacts. Yeah, Dawn.
Didn't we, remind me, earmark a percentage of the money to go towards mental health and substance abuse?
Yeah, we did.
For the tax?
For the tax.
Yes, okay.
What was the percentage again? Was it
I
50?
don't remember what it was.
The sales tax?
Yeah, we did that at the annual.
Yeah, that's what I just couldn't remember.
And it
But-
was the sales tax or the community impact?
The sales tax.
Sales tax? So 50% of the sales tax is for,
Some percentage of it.
Okay.
I would have to double check.
It was either 25 or 50, and it was specifically slated to be sort of doled out by the CRSA,
Mental health and
mental health and substance abuse.
prevention. I thought it was 50.
Yes.
And there is also another amount of money that comes back in from the state, from the amount of money that they're going to be collecting as well to the community at, I believe, up to 3%?
Well, so,
More than that.
I mean, that one's super ambiguous right now because nobody knows. I mean, we know how much the state is going to charge. They're going to charge an additional, like, I'm trying to remember, 10%, somewhere in 10.25, somewhere in that range. They're imposing in addition to the 6% sales tax that they would already collect on retail sales anyway. So they have their own excise that goes to the state. Some of that is expected to come back to the municipalities, but that's the state's call to make. There's no specific formula anywhere that guarantees any community a particular percentage of that, and that's, part of the state's general funds. So the only one you're guaranteed is the 3% local that you impose. Yes.
For the medical marijuana, is that the same tax?
So the medical marijuana is different because it is tax exempt as a medical product. So there's no sales tax on marijuana for medical use. There is, however, the same 3% host community impact fee can be charged of medical dispensaries as well. All right, that was actually the end. So I am happy to answer any questions. Yeah.
Can you just give an idea of what would happen if, I've heard a lot about regulations and limitations and things of that nature. What would happen on Nantucket if kind of nothing was done, moratorium ran out? I know there's a lot of regulations on freestanding structures and things like that. Is there any idea from the town about how many of these things could open? We've heard a lot from the selectmen on, we don't want to be a party town and this would be the wild, wild west, but I've never actually heard X number of places could open in these specific zones that have been outlined.
Have we done like a feasibility on how many could potentially?
Or just give an idea of
Yeah.
voters decide that they don't want to adopt any of the regulations. What kind of things are we looking at in the areas that are allowed to have happen?
So if the moratorium expires and nobody does anything, the zoning that I covered in summary is what then becomes effective. And so anybody that wants to locate would have to find a standalone building. It would have to be in the CN or CI district. They would have to get a special permit, and they would have to get the Board of Selectmen sign off on a host community agreement, and they'd have to get their state license. So if it's as many entities as, number one, the market can support, and the zoning in those limited districts could, locations they could find with respect to distance from school and all of those parameters.
Is there a number on that? Do you guys have any idea of how many places could open?
I don't think we have a specific number.
You can limit it to 20% of the package stores, is that correct? Right? And how many package stores are there?
You want to go ahead? I believe there's eight package stores. So
Annual.
yeah, and so it's based on the annual package store licenses, not your seasonal. And so with 8, that's 1.6, rounds up to 2. If you wanted to have, if you wanted to limit it to 1 only, then you would have to go to a ballot vote. But above 2, you're above 20%. That doesn't require a specific action.
But it does, the general bylaw, correct? If we want to limit it.
If you want to limit it to 2, you can do so by a general bylaw, and that's been a recommendation that I've made with respect to putting in place a limitation. It could be a limitation based on a specific percentage, or you could choose a specific number and impose that limitation numerically.
And how many applications do you currently have before the town?
So that's
Depends.
depends on how you define application. I think there are 3 entities that have expressed interest in opening retail establishments at this time.
Recreational.
Well, 2 are medical with perhaps some
Okay.
indication that they would want to also do recreational.
And the cultivation would have to be here, correct? Because they can't take it over the water.
That's correct.
So, are we concerned about like any kind of chemicals or anything like that? Are we gonna try to impose anything on how those, because California did have some issues with, some chemicals that were sort of used for various plants. And I'm assuming anyone who uses marijuana wouldn't probably want those chemicals ingested anyway. So I'm wondering if that's something that we could, sort of request, or can it be organic? I don't know. Is that something that you can impose upon a licensee?
Yeah, so those are really good questions. One thing that Massachusetts has the advantage of is that there were a few states that came before us with respect to legalization, and I think the Cannabis Control Commission, learned a lot from those states that went before. We have some of the strictest state regulatory requirements with respect to things like pesticide and dosage and things like that. But again, the host community agreement is one of these tools that's been given municipalities to address things like that. And so if a community decided that they were concerned that the state regulations didn't go far enough and that there were additional areas that they wanted applicants to comply with in terms of pesticide. I mean, another one that I've seen is odor control. Like, what are you putting in place if you're growing and processing in terms of managing that odor and make sure it's not a nuisance in the neighborhood? Then those are the conversations that you have with the applicants in their initial permitting stage, and you say, I want to see what your plan is with respect to, wastewater management and with respect to, the amount of electricity you're going to use and whether you're going to use renewable energy for some of these growing operations. And we want to commit some of these things to writing and build them into a host community agreement so that we're making sure that our community is not going to be unduly harmed by the drain on resources or the potential impacts that might result from having these establishments operate on a large scale.
And I did read
I
that
think we
there
have a
was
question.
some
We have a
impact.
question up here.
I'm
Sorry.
sorry.
Claire has to ask a question, if you don't mind just raising your hand, so I
Okay.
can hand you the microphone.
Of course, yeah. Go ahead.
I'm just wondering if there are going to be, or could there be, expiration dates on the licenses if we're limited to the number of establishments for non-use of the license, so we don't have the same thing happen that happened with the medical licenses and the person or the group gets the license and then just sits on it just to sell it later on.
Yeah, so again, this is something that could be built into, and I know that Planning Board and the Board of Selectmen are looking at these types of issues. This is something that could be built into a special permit where, somebody comes before the Planning Board, they get their special permit. If they don't use it within a year, you put a term limit on how long that special permit is good for, and then, it expires if they haven't taken the steps necessary to exercise that special permit within a reasonable amount of time. But currently, that's the sort of thing that we're exploring with respect to local regulation to make sure that these sorts of things are addressed.
Is there any way to, well, I want to go back to the testing lab, since we can't test the products by sending them over. We would be requiring some testing here, correct?
So the state is going to require a minimum amount of testing take place on these products, and that the products are then be sold with a warning label that basically acknowledges that they have only been subject to a reduced threshold of local testing, so that anyone who's purchasing the product is aware of that limitation with respect to Nantucket products.
And does that testing actually determine the level of THC?
That's a good question. I'm not sure. I know that it looks at, for example, like pesticide and contaminants to make sure that the product itself is, I'll have to look into that and make sure that the THC is included in that.
The stuff you get from the medical establishments, all of that is detailed, but I don't know whether it's tested for in the same test as the fungus and mold and pesticides and that sort of stuff.
I mean, there is a requirement that any product that be sold that have no more than, I think it's, the limit is like 5 milligram THC. So based on the fact that is a requirement of state law, I think there's going to have to be a testing protocol for the amount of THC in the products that are manufactured here, because otherwise there would be no way to verify that those products are in compliance with that stricter standard of the amount of THC in a product.
And do they require a security person to be on the site?
There are security requirements that are detailed in the regulations with respect to cameras and security personnel. In fact, their security systems they're required to have 2 tiers of security, both a primary security, and then that security system has to be monitored by an independent secondary security company, so that there's not just one layer of security in charge of that facility. The state regulations on the security side are quite strict for the retail, for the cultivation, for all of the facilities. Even the outdoor growing facilities are required to be fenced and with cameras and locks and alarms and all kinds of protocols.
One of the things I did notice out in Colorado was surrounding these. I went to one that was sort of like a Walmart, quite honestly. It was full of so many different things, and everybody seemed to be doing the product out in the parking lot or behind the building. So I think that would be something we want to look at, and hopefully that security person could help with that.
Yeah, it is. In Massachusetts, it's currently against state law to consume marijuana product in public spaces. So that in and of itself would be unlawful. Did you want to? Yeah. Do you want to repeat?
So, who will be doing the testing if there's no actual testing facility?
If there's no testing facility, then the cultivators and manufacturers of the product here on the island are going to be required to do their own testing, and there will be state testing enforcement people that come and verify, but it's not going to be part of that state laboratory system.
I had a question on the CHAs, kind of what Mr. Sutters was talking about. No limit happens, and it's unlimited in how many that could be here, ideally, right? Even though it would be hard with the zoning that we have and all the regulations. How much does the CHA, how much control is there? So I guess, for example, 3 new licenses come in, now we're up to 6. How much control does the select board have to say no for whatever reason? Is it only the buffer zone? Is that the only thing that we could deny the CHA?
No. So, and this is something that's, going to be sort of fleshed out over time. I think the intention of having this be a municipal requirement was to give some degree of local control to be able to say no. Now, you can't just arbitrarily say no to everybody who walks in the door. And I think if you did that, there could be a challenge brought against the town to say, well, you've effectively prohibited these uses by denying host community agreements to everyone who walks in the door, regardless of who they are. But if you are going through a process of meeting with applicants, evaluating their proposals, looking at the locations where they're proposing to locate, looking at what the market looks like in general across the community and the issues that you're facing, and you reasonably feel that an applicant is not a good match for the community, then I think there is built-in discretion for boards of selectmen to deny host community agreements to applicants they are not comfortable with. There's not a built-in appeals process. Nobody is, monitoring the fact that you say no to a particular applicant. They would have to, if they wanted to challenge that, we've talked about this, but it's not even clear what kind of legal action would potentially lie against the town for refusing to contract in an area where there is some discretion as to whether you contract or not. So I think that this is not, this is a tool. This is something that can be used. It just has to be used reasonably.
Do you see other communities who are in the yes category, limiting to 3 retail, 6 cultivation, or do they just, kind of what are other communities doing that are in the yes category that don't have our specific kind of hurdles of the air and water?
The most common limitation that I'm seeing is a 20% limitation, a cap at 20% of retail sales, and then a numeric cap on other types of marijuana establishments to specific numbers. So for example, you would cap your retail sales to 20% of your liquor licenses, and then you would have an additional provision that would say there shall be no more than 2 licenses issued for marijuana cultivation, product manufacturing within the community. And it's still subject to all the zoning, but you've imposed a similar cap with respect to the other types of uses. There's no provision in the act that puts in place a ballot vote requirement on a limitation of cultivators or product manufacturers. The only time you're going to a ballot on a limitation is if you're looking to limit a retailer below the threshold that we talked about. So there is discretion for municipalities to impose other types of limitations on other types of uses if they want to do so.
Through general bylaw.
Through general bylaw. Mm-hmm. Yep.
Thank you. When you were calculating the 20%, you went to 1.6%, 1.6 facilities, and you automatically went to the concept of rounding up.
Mm-hmm.
Is that the law?
It's not specifically written into the law, but there's been guidance issued by the Cannabis Control Commission that indicates that's the way that they would view that calculation, and that 2 would be greater than 20%, and so it would not require a ballot vote because fewer than 20% would ostensibly be one whole license and part of another license.
That was a question we had for a while at this level.
It's something that I've raised specifically with the commission and gotten clarification from them on.
Thank you. I apologize if I came late. Did the meeting not start at 6?
It was in the paper at 6, but it was supposed to be 5.
Okay, so it started at 5. So I may have missed a little in the beginning, and I'm sorry for that. I do have a couple of questions. One is the town trying to figure out a way to limit recreational marijuana, or would they just let the market kind of figure it out? It seems like it's not easy to open up a recreational business. So that would be a question, like, are we trying to limit it, or would the market limit it, or can you pick a number and say, well, this is how many we want to have?
Yes, so...
Is this going to be available, the presentation online at all?
Yes.
Yeah. So, with respect to limitations, I think this is what part of this, the purpose of this discussion and forum was, to get impact or input from the community with respect to whether there was interest in having specific numeric limitations, or whether there was interest in sort of allowing market forces to determine how many establishments could locate, or imposing those limitations through, more stricter, rigorous buffer zones or other zoning determinations. The one point that we did talk about with respect to limitations is that if you go below a certain threshold for retail marijuana establishments, there's going to be a specific statutory process you have to follow to implement that. So the number that we've sort of been talking about is, 20% of alcoholic beverages licenses. If you limit it to 20% or greater, you can impose that type of limitation fairly easily, procedurally, through just the enacting a general bylaw.
Came in a little late too, so I'm not sure if you mentioned this, but I was wondering, is there a state ban on edible marijuana products in recreational outlets?
There is not. There are, however, some fairly strict standards with respect to what those products can look like, how they can be packaged, and how they're portioned. So, for example, edibles cannot take the form of other commercially available candy or other products. So you may have seen in other states, like, things that look very much like a package of Oreos, but are labeled a little bit differently. all of that is out in Massachusetts. It has to be clearly identified as a marijuana. It cannot be attractive to children at all. The packages have to be resealable. The portion sizes have to be easily identifiable if it's a multi-portion package. The THC limit has to be below 5 milligrams. So they have tried to manage the edible market in a way that makes it, the least attractive to children and minors, and helps people to identify what it is they're consuming.
Is that something towns have tried to curtail as well? Can they have any control over whether or not they're even sold?
Yeah, so I mean, a large part of the recreational marijuana market is in edible products, and some people actually prefer that to the smoking, which has other secondary effects on people around them. Some communities, when we were on the medical side and we were doing host community agreements, we sometimes had communities that put in a host community agreement, a limitation on the sale of edible products. And some companies were willing to make that concession on the medical side because their medical products generally took other forms. Whether or not a company would agree to limit or restrict the types or amount of edibles that they sold would be a point for negotiation in a host community agreement, but that's really the only way you could get that kind of a limitation, and you couldn't impose just a general ban on edibles because I believe that would conflict with the state law which allows those products to be sold.
Okay. And also have another question. What about vaping materials? Would recreational marijuana outlets be able to sell devices for vaping, or the THC chemical for vaping, or nicotine for vapes?
If it's a marijuana establishment, it's going to sell just the marijuana products. They're not going to be able to have tobacco products mixed in with your marijuana products. But yes, the vapes and the product that you inhale, that is all part of that retail market.
So it sounds like to me, a lot of things that I'm hearing is the host community agreement is really important for the public to be involved with that. And that's where things can be discussed, negotiated, talked about when and if that happens.
Are there bylaws that the town is currently considering, or are there things that you guys have started to try to flesh out in terms of restricting use to certain areas, or are there things that you're considering for the meeting?
It's already restricted to one area
Right.
that we looked at, so that's already been done. We voted on that before.
Mm-hmm.
I think what Katie said earlier, we're having these forums to get public input to really see what we're going to put forward in the special town meeting.
Mm-hmm.
Are we going to ban it? Are we going to limit it to 1? Are we going to limit it to 2? Or do nothing? So if you ban it or put it to 1, then it has to go to a ballot. You need a general bylaw and a ballot, correct?
Mm-hmm.
Both. If it fails, like say we tried to ban it, it's one of the things that we talked about a couple weeks ago at the board meeting. If it fails, then it's back to wide open, unlimited.
Mm-hmm.
So we're trying to get a feeling from the public and make sure everybody understands that can happen. But if we limit it to 2, it's a general bylaw, not a ballot. Will that pass? Do we start off slow? Yeah, so Don wants to comment on that.
Katie, can you help us a little bit more on the limitation in terms of the timing? Because if we limit it to 2, say,
Mm-hmm.
and we've signed 2 letters of non-opposition now, and those people aren't necessarily moving forward or aren't moving forward quickly, and someone else wants to do it that might be a better proposal, might be, at what point do we get to cancel out? I know you talked about the special permit, which is fully locally controlled, but what about at the state level? If we've limited to 2, can we roll back
Yeah.
a granting of a letter of non-opposition?
That's a really good question. So just one little point of clarification is that on the adult use recreational side, there is no letter of support or non-opposition that gets signed. It's only a host community agreement. So,
Host community.
so if the host community agreement has been signed and they have a state, and you have a limitation of 2, and you've signed 3 letters, then it's kind of a race to the finish as to who gets through the permitting first. I mean, that's something you can sort of control by, only signing, 2 at a time. But again, revoking a host community agreement once you've signed it is going to be a difficult thing to do because it's a legally binding contract. So if an applicant fails to go forward and they seem to be stalled, and there's somebody else in the wings who's ready to go and can get through that process faster, then arguably you could sign a third agreement and they could get that license, and then the person who stalled would be out of luck if they can't accomplish what they set out to do in a reasonable amount of time.
Even if they were originally approved as medical and have a grandfather.
Yeah, so.
But if they've changed, if they don't have a location, say, now, they will have to come back to the board, and there may be.
Yeah. So now we're sort of talking about 2 different things, because on the medical side, it's, as you know, we have an issue with the stalled applicant and whether or not they are entitled to certain protections, and that particular entity has not made very much progress in the last 5 years. So I think there are some options for the town with respect to that license and how that gets addressed.
Yes, to some extent I asked that because I think it has some bearing on if we are going to do a limitation or propose a limitation, whether it might be 2 or 3.
Or 4.
Yeah,
Or 4.
or 10. I mean,
Or 10.
Right. That's what we're talking about. That's what we want to know. Because we have to propose things for the fall town meeting. And we can propose nothing, or we can propose 10 different articles. But that's what we need to hear from the voters, what they want us to put forth.
I was out at the Medwell event out at Cisco Brewery today, and there were 100+ people there. I'm wondering whether, I can't remember whether the medical licenses are tied to the recreational licenses. Can you give more medical than you do recreational, less? Can you clear that up a little bit?
Yeah, so the medical are not tied specifically to the recreational. Anybody who gets a medical license could propose to co-locate a facility, medical and recreational retail sales, but they would have to go through the full permitting process and sign a host community agreement on the local level and on the state level with respect to that recreational use. They don't necessarily just because they opened a medical, they don't get to open the recreational. The only exception to that was this priority applicant status that happens for anybody who is provisionally licensed prior to July 1st of 2017. There has been one applicant in the town that fit that criteria, but there are some questions with respect to whether or not they've executed on that.
But if we decided to go for 2 medical and then we decide later on to go for a 3rd one, that wouldn't open us up to having to approve another recreational?
No.
So just to say it again, recreational and medical are 2 separate hooty dooties. So if we want 5 recreational and 1, if we want 5 recreational, it's nothing to do with how many medical are on the island, correct?
That's right.
All right, that's all.
But
We're done.
a medical can also engage recreational marijuana. So it could be in the same facility.
Only if they get licensed and permitted to do both.
But it's in the same facility, right?
Potentially, they could do it in the same facility.
But they have to meet all the same criteria, right, for the fencing and
Yes, and so the state regulations contemplate the possibility that there could be medical marijuana dispensing in the same location as retail sales of adult use recreational marijuana. And they have some regulations with respect to how those transactions take place. There has to be, separate areas in which those sales take place. There has to be a virtual separation of product. There is a regulatory scheme in place to address co-located establishments on the state level with respect to tracking of the sales and the product. Yes.
On a different note, I took a look, or I was at some of the previous meetings, and there was somebody brought up a very good question about whether the people of Nantucket, the board, select board has worked with or contacted any of the towns with a similar dynamic to Nantucket, say out in Colorado. What came to my mind was Aspen and Vail, where Aspen, in their off-season, has approximately 6,800 full-time residents. They have 5 local dispensaries in the town of Aspen. Vail has approximately 5,000 full-time residents, and they have 3 dispensaries within Vail. We have, well, who knows, 17 to 20,000 full-time residents, and we're talking about 2 or 3 or maybe 10 dispensaries. And my question is, has anyone from the board been in communication with people from those 2 towns, which again have similar dynamics, to figure out if it's working for them, or is it not working? I mean, I would think that since they have been approved for numerous years, that they would have some background at this point as to whether the numbers are there, would those numbers work for Nantucket, or if they feel they have too many based on the number of people that live in those communities.
That's a good question.
Road trip. Come on.
That question was asked 6 or 10 months ago.
And
you guys said no. None of you had even reached out to anybody else.
So
But I
my
guess
question
my
is,
real question, is the board so against what the public has voted yes for? Because you guys are making it as difficult as possible. And here we are, how many years later, still waiting?
So I can speak to that. I personally, I can't speak for the rest of the board. I want to make sure.
I'm joking, I would never. Oh, no, not for me.
Did you mean that for me?
Yeah.
You keep.
Sure. So saying I can't speak for the board, but I know when 63% voted yes, Nantucket, I don't know if everyone knew everything what that meant. I don't know if they knew if that was medical or they just wanted 6 plants at home and they wanted to be able to give it to a friend, right? And not, and not be criminalized. I want to make sure everybody understands what they voted for yes. So 6,500 of our 9,000 registered voters voted yes. It wasn't 65% of 9,000, it was 65% of the 6,000. I just want to make sure everybody understands what it is. And I think the board's trying to do the due diligence and ask questions of, do we want to limit it to 2? Do we want to do nothing and just let kind of the market happen and see? It's a very narrow area. I don't think, just in my opinion, that 10 are going to pop up. It's extremely difficult to start one of these. Just the process that you described and how difficult. There's not a lot of options, I think, real estate-wise, just from how I've been watching. So I don't think we're trying, I personally think we're trying to do our due diligence, not trying to stop it. I can't speak for other board. Everybody has a little different feeling on the board, and I can't speak for them. This isn't an open session for the board. So I hope that helps a little bit.
I'll speak loudly so I have to bring it over. If there is a ballot question, does it have to pass by 51% or 2/3?
It's just a majority.
What is, you just mentioned the growing in a household. I'm going to have to hand this right back to you. What is the law on that? I don't know what the law is on growing in a household or individual.
So what we've been talking about tonight is really the commercial side of the marijuana industry. When ballot question 4 passed, there was an entire personal use side that also got approved, which we didn't really speak to tonight. But under that personal use, you can possess up to 1 ounce in public. You can have 6 plants that you grow in your home. If you have 2 growers in a single location, you can have up to 12 plants total per residence. You can have 10 ounces in your home of the product that is generated from those plants. And there's some requirements with how that is secured and whatnot. There's no ability to consume in public spaces, but you can certainly consume in private locations.
Is it 12 flowering?
No, only 6 flowering at a time.
What was that?
6 per person.
Flowering.
You would only have 6 of your 12 plants in flower at one point.
So who is up here to create bylaws at this point? Are you waiting for citizens to come forward with bylaws, or are you thinking of putting them out there and seeing?
So we're trying to get feedback, and we talked about it a lot at the select board meeting. It's been on the agenda where anybody can come and talk to us. We're doing these public forums to try to decide what we're going to put at the special town meeting, right? Limit it, ban it, do nothing, limit it to 10. Right, so that's why we're having these, to discuss what we're going to put on the agenda, because I have people coming to me who are pro-marijuana that don't want any retail. They like it at home, they like their system, they don't want any retail. And I have other people who want retail, want capitalism, and the markets will just let it happen. It'll work itself out. And I have other people who want to ban it 0. So I'm personally trying to get a feel for what's the majority of that 65% that said yes. What does that look like here? If we do it, do we go slow? Do we just open it up?
Yeah.
I did think when I was voting, it was just on medical use. I didn't know I voted for
Florence,
So, I'm sorry, I got here late, so if the town does nothing, keeps it the way it is, you can't have more than 2?
No, it's unlimited right now.
Can you explain that real quick?
Yeah. So as of right now, there's no specific numeric or percentage limitation on the number of establishments that could locate. The only limitation is with respect to the zoning districts that have been designated for where they can locate. And I can go back to the map right here. Whoops. Right now, these are the areas of town that adult use and medical marijuana are permitted to locate. They require special permit from the planning board. But those are the designated pieces of property at this point in time.
What's red versus blue?
I think one is the CI and one's the CN. I think red is CN.
Yeah, the red is CN.
CI.
Yeah.
So if you want to get a sense of the meeting, I would say that I enjoy using cannabis. I appreciate that it's legal now. I appreciate that I can grow it at home. I appreciate that other people grow it at home so I can trade with them. We don't do any selling, but it's pretty awesome to have access to it. Someday I'd like to go shopping for it. I can understand the town's desire to not go crazy Wild West all at once. I think it would make sense to find a number that works to say, look, if we allow 3, it might make it through town meeting. And, let's not let people deliver marijuana. They talk about delivering marijuana, that sounds scary. So let's not have them do any deliveries. There could be 3 stores. I think that might work for discussion and for something to happen. I think if the town tries to say, we're going to hold this back to 20% and it can only be 1.6, or it can't be this and it can't be that, I think it may not pass. And then I'm not sure what you're stuck with after that. So I think it would make sense to pick a number that would say, look, there can be a couple of these. I think people realize how hard it is to put one in. You don't just show up with a bunch of cases of Bud Light and start selling liquor. And if you pick a number that's not a crazy number, we're not gonna say 10. And, you know, I heard some of the selectmen discussion where they were like, we don't wanna get this going too fast and not be able to pull it back. And if you allow a couple of establishments, and I think it would be a great idea to limit delivery. I heard people, I mean, I don't know who's driving around delivering cannabis.
Yeah.
I don't know if you can limit delivery like that.
So right
That
now,
would be my input.
as of right now, there is no delivery license available on the state level. So delivery, like home delivery, is currently not going to be something that municipalities even need to regulate for because there's no available state license in that category. And that may change, at which point, you know, municipalities can look at that. But there's, yeah, I mean, Nantucket's unique because it's an island, but there is a restriction in other places in the Commonwealth that you can't prohibit transportation through your community if you're a community that, you know, limited delivery yourself. Your citizens can still get delivery from the neighboring town.
Question. So if the host community agreements are 5-year terms, and say 2 years, the state says anybody can do delivery. Should we, or even can we, in the host community agreement, negotiate for recreational no home delivery? Is that something that you would put in there? It's not a general bylaw or
Yep.
anything like
It could
that?
be part of your host community agreement.
If we wanted to do that, maybe we wouldn't. I'm just trying to think of.
Or you could say, you know, no delivery, and you know, unless approved by the Board of Selectmen as an amendment to this agreement.
Right.
You know, you can leave the door open.
If the state opens it up, then you have to come back.
They have to come back.
Something like that.
Yep.
If I could make a comment, I'd just like to caution the selectmen in doing that. I read a story, and I think it was in time.com, about how much opioid use goes down in communities that have a medical dispensary. And it's a somewhat substantial number. How much it goes down if they have medical with deliveries, it goes down more. If they have recreational and medical with none, it goes down, I think, like 25%. If it's just walk-in, and if it's deliveries too, I think it was like 32%, the opioid use went down. So I would get the selectmen, I would recommend to the selectmen, get it going fast, so that hopefully this will help us with our opioid problems. Thank you.
I have a question for you, for everybody here. Is this helpful? It's a lot of regulations, it's confusing. Is it helpful at all, kind of understanding where we're at as a community?
It is.
Rachel Day had a link that she sent to the Alliance for Substance Abuse Prevention Board that outlined all these laws, which I tried to read before I got here, and it's a lot. But if people had an interest in it, maybe you guys could just post that link so that people could actually start to look at what is currently. Some of those laws are changing at the state level, and of course, our laws may change at the local level, but at least you'd have a general idea of a lot of the things that she highlighted. And it might answer more specific questions.
We get giant emails from Katie all the time with all these regulations we've been studying, but trying to kind of serve them to the public that they're understandable is what we're trying to do with this forum and the one on June 4th at, I think it's at the Nantucket Inn.
Let me ask, if you go to the website and you just type marijuana, it will show up the page that we have where you will find all of our presentations, all the forms that we have, and actually the CCC webpage and all the updated information is right there.
Okay. And the time of that meeting at the Nantucket Inn on June?
That actually is at 6 o'clock.
That is at 6 o'clock. Good to know.
It is 6 o'clock. So Harvey, since you weren't here at the beginning because of the time thing, the Chamber of Commerce and the radio station are sponsoring a community forum on Monday, June 4th at 6 o'clock at the Nantucket Inn. And the purpose of that is not for it to be hosted by the town, but for these other groups to host it. And the idea is that the public would give their input, feedback, opinions, comments about what they think the board ought to do.
Thank you. And for what Jason said about sharing this stuff, it does help for us all to realize this isn't just something simple. for you guys to have a meeting and say, here's what we're gonna do. I mean, the more we understand how complicated this is, the more maybe people will understand that you're trying to figure out how to make it.
I think
No, go ahead, nope.
Okay. Last time you were here, I asked a question, if we were to give 4 recreational licenses, and we had a change of heart 2 years after that, can we pull it back? And you said, I think you said no. It was more complicated than that? Your answer?
Yeah. I mean, once you've allowed something under zoning, a certain protection attaches to that use once it's in operation. And if there's a subsequent change in your zoning, so for example, you restrict something that in a way it wasn't restricted before, anybody who's operational is grandfathered in effect. Now, if we were talking a general bylaw and the general bylaw said there should be no more than, you started with 4 and then you pulled it back to 2, I think what you would have to do is over time, if some of those entities went out of business, you just don't create new licenses. But anybody who would already be in business, you couldn't revoke a license and shut them down because you changed your general bylaw.
I don't ask that as
Yeah.
a scare tactic.
Yeah.
I'm just trying to look at the whole picture. It doesn't seem like something we would do. The market
Right.
would probably just work itself out.
Yeah.
And I think that's the bottom line, is the market's gonna work itself out. When you think of, let's just say you're gonna have, bear with me here, 6. 6 businesses are gonna have to be able to be viable and rolling it, with all the regulations, with everything that goes with it. It's not likely that it could happen. So I don't know that you'd have to limit it right away to 6 or even to 3. Because I think the market's going to take care of itself. These guys have to do their own growing here. I mean, there has to be a place that can be their production for both medical and for recreational. It seems highly unlikely that 6 could pull it off with their warehouses and stuff. When we're looking at the huge amount of canopy space, in order to pull that off, it's crazy. It's crazy to be able to think that 6 would, and I'm for it. I'm for 15. If 15 can make it here, God bless them. I don't think it's reasonable. And my other thought was having to do with home delivery, because we talked about this a couple weeks ago at the select board meeting. It's the only people who would ever benefit from that is somebody who's in the medical, who's a medical client, because they can't get out. But I'll tell you what, if we don't have delivery here, I will go to the recreational place, pick up whatever they need and drop it off for them. I would do, you can arrest me at the time, but if somebody needs it, they should be able to get it. Now, there's a lot of people that, with medical, that's why they have it, is because they need it for the pain or for whatever they're going through.
And perhaps I could just clarify on that point. Again, medical, regulated by Department of Public Health, does allow for home delivery. It's the recreational home delivery that is not yet licensed by the state.
Right.
So.
And I was just saying that from the point of view of the select board. That's a whole different area that is really tricky. Is the whole medical, the client's medical, because that's most of the reason for cannabis anyway, for the most part, is the CBD in it, not necessarily the THC. So that was the thought that went through my head. I decided moving over here, I thought.
I think there's licensing available for caregivers as well. So you can get like a medical marijuana license if you're a caregiver for a person who needs. Because I just went to the forum at the brewery, and that was one of the things that they were talking about.
Good to know. So much information. Is there anything else you guys need to know from us? I mean, you already know that I'm in favor.
Good feedback. You got it.
One more thing. Oh, go ahead. I have one more thing for anybody who is hesitant about moving forward in the whole recreational marijuana world. There's a book, pretty recent, called Weed the People. First 30 pages is all you need. And it will calm some fears about what's happening in the United States and specifically about potentially our community as well. I can't even remember who the author is off the top of my head, but it's a ridiculously important read having to do with why we are so fearful about marijuana versus even alcohol or opiates or anything else. So I challenge you. Oh, I'm sorry. I'm going the wrong direction.
If there's no more questions, I guess.
Thank you all for coming. Thank you, Florence.